everyone, and welcome to this webinar on charity incorporations. This is the third webinar in Russell-Cooke's mini-series for charities. The first was returning to the workplace after lockdown. The second was changing the use or occupation of your charity's property. And this is the third one. They will all be available via Russell-Cooke's website and on Russell-Cooke's YouTube channel. So please do access them and pass on links if you know anyone else who would be interested. So this webinar is going to be a presentation of roughly 30 minutes, and it's entitled "My Charity is Unincorporated, Should We Incorporate and How Do We Do It?" And it will be followed by around 15 minutes of Q&A, in which I will aim to answer as many questions as I can, but if there are any that I can't answer in that time, or any that are a little bit more specific to a particular charity, I will aim to come back to you individually after the webinar. So, my charity is unincorporated. Should we incorporate and how do we do it? A logical place to start seems to be by asking, what does it mean for the charity to be unincorporated in the first place? So there are a variety of legal structures available to charities. Charity is a status or a label, if you like, that you can stick on various types of legal structure. I've put the four most common types of legal structure that charities have on this slide. So they are unincorporated association, charitable trust, a charitable company limited by guarantee, and a charitable incorporated organisation, also known as a CIO. Those types of legal structure can be broadly categorised into two categories. The first is unincorporated, and the second is incorporated, as set out on that slide. The process of incorporating a charity involves swapping your legal structure from an unincorporated structure to an incorporated structure. And there are several reasons why charities may want to do that, which I'll come on to on the next slide. Before I do that, I should just mention that there are other legal structures that charities can take as well. In addition to those four there, for example, royal charter bodies and community benefit societies. They are less common and they don't tend to come up in discussions around incorporation. So I won't be talking about them in this webinar, but just to make you aware that they do exist and there are some charities with other legal forms as well. So why do charities sometimes want to incorporate, to swap from an unincorporated structure to an incorporated structure? The primary reason that's often cited by charity trustees for going through this process is to help with the risk of personal liability to charity trustees that can arise when you have an unincorporated structure. So an unincorporated charity has what lawyers call no separate legal personality from the individual trustees who run the charity. That means that the charity's legal relationships, its contracts, its property, etc., legally speaking, are held in the name of individual trustees. That also means that if a liability arises in the charity, it's against those individual trustees. And if a third party were to bring a claim and to sue the charity, it would need to sue the individual trustees because they are the only ones who can be sued in that way. In the vast majority of situations, the trustees will be able to access the assets of the charity to meet that liability. So cash in the bank, or it can sell some of the charity's assets to get sufficient cash to pay off the liability, or hopefully there will be proceeds of a relevant insurance policy as well. However, as I'm sure you can appreciate, there are situations where it's possible that a large liability can arise and the assets of the charity are insufficient to meet that liability, and there isn't insurance, or the insurance doesn't cover it for whatever reason. In those situations, because the claim is against the trustees personally, there is a risk to the personal assets of the trustees. By contrast, if a charity is incorporated, so if it's a company or if it's a CIO, it has separate legal personality, and the charity itself can hold all of those legal relationships. So if a liability or claim arises, it's against the charity itself as a legal person, and not the individual trustees. Ultimately, if in that situation with an incorporated charity, there is a large liability that can't be met by the existing assets of the charity could go through a statutory insolvency process and wind down, and the individual trustees would nevertheless be protected. So that's often cited as the primary reason for looking at incorporation. The actual practical risk to trustees will vary greatly between different charities, because it will depend on how much money they have, what their assets are, what their operations and business model look like, and therefore how risky what they do is. If a charity is largely made up of a pot of money and it makes grants, it's fairly low risk probably. Whereas if a charity interacts with the public a lot and has staff and complex contracting arrangements, it's probably got a higher risk profile. I should just mention that regardless of legal structure, there are limited scenarios in which trustees can still be personally liable anyway. For example, if you breach fiduciary duties. So for example, if the trustees knew the charity was insolvent already, but they nevertheless continued to contract with third parties, continued to promise payment when they knew that couldn't happen. The second reason I've put on that slide is very much tied to the first, and it's the ability to attract new trustees. So clearly, if someone is coming to a charity afresh and it doesn't yet know anything about that charity's operations and its risks, or relatively little about its inner workings, understandably, they may be more reluctant to become a trustee, where there's a risk of personal liability because the charity is unincorporated. And if you ever have the pleasure of trying to attract a lawyer to your board, I'm sure they will ask that question as well. The third reason I put on that slide is in relation to administration and the ease of charity administration. So again, because an unincorporated charity holds its property and its assets in the names of individual trustees, those trustees clearly change over time as the years go on, and it's necessary for charity records to keep up with that. As I'm sure many of you will know, in practice, charity records often don't keep up with those changes, and that can cause difficulties in future. For example, if a charity holds an interest in land and 15 years after obtaining that interest it wants to enter into a transaction, it may find that the names at the land registry are still the 3 trustees who were in post 15 years ago, and one of them has moved abroad, one of them doesn't want anything to do with the charity, and the other one may have died, for example, in which case it can be difficult to sort that out, and it can involve extra cost and hassle for the charity to sort that out. The final reason that I've put on this slide is in relation to external perceptions of the charity and why that can sometimes be a reason to incorporate. So incorporation is sometimes thought of as part of the professionalization of a charity. So we have had clients who have cited third-party requirements as a reason that they have decided to incorporate. For example, to achieve a particular accreditation to become eligible for a particular pot of grant funding, or sometimes to help with a particular bank transaction that they want to enter into. So there can be some specific reasons as well. As I say, just to go back to the main reason charities look at incorporating generally is this issue around potential personal liability to trustees. So that's the one that tends to be focused on. And although the risk varies from organisation to organisation, some charities take the view that even where their risk profile is relatively low, because trustees are generally speaking unpaid volunteers, we don't want them to have to take on any risk or as little risk as possible, and therefore they prefer to incorporate. So moving on to the next slide, the other side of the coin and reasons why a charity may choose not to incorporate and to stay as they are. The main one is the cost and effort and resource that can be involved in incorporating. So it's important for a charity to do a due diligence exercise at the outset when it's considering whether to incorporate, and to work out what assets and liabilities it has, how difficult it might be to get those across into a new incorporated charity in due course, and whether there are any big hurdles to that taking place. So one example of what can be a big hurdle and can put a stop on a plan to incorporate is if an unincorporated charity has a defined benefit pension scheme. The process of incorporating and transferring that across to a new incorporated charity will generally trigger a large liability under that pension scheme, and sometimes the size of that liability can be a barrier on the incorporation taking place, because it would immediately result in the charity becoming insolvent. So clearly it's important to identify that at the outset, and if there are any big barriers, to take that into account in the trustee's decision about whether to incorporate. The cost and effort involved will vary greatly depending on organisations. So again, going back to my earlier examples, if a charity largely consists of cash in the bank, that's sometimes quite easy to transfer across, although dealing with the banks is sometimes painful. Whereas if a charity has lots of complex contracts, it's got employees, it's got interests in land, etc., there will probably be some more work involved in incorporating. But at the same time, those types of charities probably have a higher risk profile, so probably want to put that effort in anyway. From a governance perspective, there are sometimes some governance hurdles to overcome when deciding whether to incorporate. If you have a wider membership, a charity with a wider membership will almost certainly have to get the membership's consent before incorporating. Generally, we tend to find that memberships are fairly receptive to a recommendation of the board, particularly if it's come with professional advice, but that's not always the case. And if you have a very large membership, there may be administrative hassle associated with putting that type of decision to the whole membership, etc. So it's worth taking into account. And the final thing just to mention on this slide is filing requirements. So if you're a very small unincorporated charity, you may find that you have simpler filing requirements now, and that they will get slightly more complex if you incorporate in future. If anyone does want to check the filing requirements for their particular charity, if you Google charity reporting and accounting, you will find the Charity Commission's guidance on that, which sets out the different requirements for different types of legal structure and various thresholds of income as to what kicks in when. So it's always a judgment call as to whether to incorporate or not. The board should consider that and go through some of the things we've talked about. If they do decide to incorporate, how does it work? How do they actually do it? The first option I put on this slide is full incorporation, which involves a transfer of assets and liabilities from the old unincorporated charity into a newly established incorporated charity. So in the example there, it's a transfer from an unincorporated association to a CIO, which is a new organization with a new charity number. That's quite simple on a conceptual level. Moving forward, once that's happened, you just operate through the CIO, and that's that. The second option that I've put on that slide, which allows charities to achieve essentially the same benefits of incorporating, or very similar anyway, is use of a corporate trustee. So this is available if you have a charitable trust, and rather than changing the charitable trust itself, that remains in place, but instead of having individual trustees in future, you set up a company, and the company becomes the trustee of the charitable trust. The individual people who were the trustees in the past will become the directors of the company. That is conceptually more complex than the normal full incorporation option, and it can lead to difficulties in some situations, particularly where it's not always well understood by trustees in years to come. Therefore, it tends to be that a full incorporation is preferred, and a corporate trustee is generally only used where there is a specific technical reason for preferring that option. One example of where use of a corporate trustee is often preferred is where a charity holds a lot of permanent endowment, and for technical reasons it can be simpler to have a corporate trustee in those situations. I won't go into the detail of when a corporate trustee is sometimes used here, because as I say, it gets quite technical. So I'll leave this slide just with the thought that in the majority of situations, charities tend to prefer a full incorporation and then just operating through your new incorporated charity in future. So full incorporation, that transfer of assets and liabilities, how does that work in detail, and what are the steps you need to go through? We mentioned earlier the need to do that due diligence exercise at the outset. That will be relevant here to help understand what you're actually transferring across. Step one is deciding on what incorporating legal structure the trustees would like in future and what's best for your organisation. So the two options are a company limited by guarantee or a charitable incorporated organisation, a CIO. A company limited by guarantee is the alternative model of company to a company limited by shares, which is generally designed to operate for profit, whereas a company limited by guarantee operates in furtherance of a purpose, in this case a charitable purpose. There are several similarities between those types of legal structure, the company and the CIO. The most important one is they're both incorporated. They both give the charity the benefit of incorporation and the separate legal personality that comes with those types of legal structure. They're also both two-tier governance structures. So they have trustees who in a company are also the company directors, and they are responsible for the strategy and management of the organisation. And they have members who sit above that and have an overarching constitutional role. They're akin to the shareholders in a for-profit, and they make key decisions. For example, if you're going to amend the constitution in future, it's the members who will sign off on that. You can have the trustees and the members being exactly the same group of people. So just one group of people controls the decisions at both levels of governance, and that's referred to as a foundation model constitution. The alternative is to have a wider membership if you're a democratic organisation, in which case that's referred to as an association model constitution. And which is right for your charity? will depend on how you've operated in the past and whether you want to change that in future or not. A few differences between the two types of legal structure to hopefully help with any decision around which to pick. Firstly, a couple of things potentially in favour of a CIO. There is sometimes a perception that a CIO is simpler than a company because it is just regulated by the Charity Commission rather than also being a company, and the trustees can think of themselves just as charity trustees rather than also as company directors. In practice, there isn't really any difference or any significant difference between the two. But nevertheless, we have found that sometimes there is a perception sometimes, particularly from prospective trustees, so it may assist to have the simplicity of just being a CIO when you want to attract trustees in future. The accounting requirements are slightly simpler for CIOs if your annual income is less than £250,000. And as I've mentioned already, you're only regulated by the Charity Commission. So, for example, when you're filing things, you only need to file them with the Charity Commission rather than with the Charity Commission and Companies House. A few points potentially in favour of a company. Companies can sometimes find it easier to borrow money when dealing with banks because Companies House maintains a register of charges. Companies can sometimes make certain amendments to their constitutions more quickly than a CIO can, because a CIO has to wait for the Charity Commission to record the change. The Charity Commission can sometimes take a while to respond. And companies can sometimes operate overseas potentially with greater ease if they're entering into lots of complex contracts overseas. Everyone the world over knows what a company is. Not everyone necessarily knows what a CIO is, as that's particular to the UK. So once you've decided on your legal structure, it's necessary to draft a constitution for the new organisation. It will look slightly different depending on whether you're a company or whether you're a CIO. If you're a company, you'll also need to register with Companies House to form the company. The next step, once you've done that, is to apply to the Charity Commission. So you have to submit a detailed charity application online, and then you may need to respond to further questions. The Charity Commission does ask quite a few questions, and they do consider these applications carefully. So even though you're incorporating an existing charity, you do need to provide full information to the Commission, and it may take a while to get a response. Sometimes they respond pretty quickly within a couple of weeks, but their standard response time is 40 working days. So you need to factor that into your timeline. The final step is then to transfer all assets and liabilities from your unincorporated charity to your newly registered incorporated charity. In order to do that, again, you'll want to look at your due diligence that you've done, where you've identified all of your assets and liabilities to work out how to move those across. And you will need to set up a new bank account with your bank in the name of the new organisation. The vast majority of assets and liabilities will be transferred across via a fairly simple transfer agreement, which just says everything in the old goes to the new on X date, with a few bells and whistles attached. However, there are particular types of asset that you will need to go through separate actions to deal with. I've listed out some examples there. So if you have land, you'll need to deal with that separately at the land registry if it's registered there. If you have a lease, you will almost certainly need the landlord's consent to assign that to the new organisation. And just to bear in mind, the landlord is likely to require you to pay their solicitor's costs to sort that out. So it's something to factor in as well. If you have employees, you will need to comply with the catchily named Transfer of Undertakings Protection of Employment Regulations, also known as TUPE. If you're not planning to change the terms and conditions of employment for your employees, often that's fairly straightforward and essentially involves providing certain information to your employees a reasonable time in advance, and most of the time they tend to be fine with that and not raise any queries because nothing is changing from their point of view. If you are looking to change terms and conditions for employees, then we would generally recommend that you take specific legal advice in relation to that, because it can cause some risks for the organisation there. Contracts and grant funding. You will almost certainly need the consent of the contracting party or the organisation providing you with the grant funding to transfer that across to the new organisation. So that should be identified in advance, and the relevant organisation should be approached accordingly. Trademarks, another thing just to note, you'd have to fill out the relevant form with the Intellectual Property Office in order to have that moved across on the trademarks register. The next bullet point I've got on there is there to remind me to explain the importance of having an indemnity in the transfer agreement. So this is the new organisation indemnifying the trustees of the unincorporated charity in the event that any historic liabilities arise and those individual trustees are sued for something that happened, say, a year or two in the past. It's important to have that in there because those individual trustees have just given everything in the unincorporated charity's bank account to the new incorporated charity. So it's important that they get that promise to be protected if something comes up from the past. When making that decision, usually it's the same trustees on the board of both the old unincorporated charity and the new incorporated charity. So they are effectively deciding to provide that benefit to themselves. They have a conflict of interest when making that decision, so it's necessary to get a Charity Commission order allowing that to go ahead. The Commission will usually give that without asking many questions, provided the indemnity is drafted in a sensible way and has sensible caps placed on it, because it's a standard thing that happens in charity incorporations. The final thing I wanted to mention in relation to this transfer is usually once the transfer has happened, the charity closes the old unincorporated charity and enters a record of the incorporation on the Charity Commission's Register of Mergers and moves to operate just through the new incorporated charity in future. However, that isn't 100% perfect in ensuring that charities left to the old unincorporated organisation will pass to the new incorporated organisation. It will work in the vast majority of cases, but some case law indicates that an unusually drafted will could result in a situation where the legacy fails, where the old unincorporated charity has ceased to exist. So for that reason, some charities that receive lots of legacies or high value legacies decide to keep a small amount of money or other assets in the unincorporated charity and keep it in existence effectively as a shell to receive legacies and to transfer them onwards. It adds a bit of complexity to the arrangement, so there are pros and cons with that, but it's something the board should be aware of and consider when incorporating. Final thing to mention is if you do incorporate and you transfer all the assets and liabilities across and you operate through the new organisation, once you've done that, you are technically operating through a new charity, a new organisation with a new charity number, so you should update terms and conditions, your website, and your stationery, etc. And that was a whistle-stop tour of charity incorporations. So I will stop recording now.